So thanks everybody for joining us today. First, I'm going to preface this that while Professor Donley is a lawyer, she is not your lawyer, and she will not be giving legal advice on which you should base your practice at the University of Michigan. However, everyone should always feel free to call our friendly Office of General Counsel, and in particular, Kate Fluelling, who has been focusing on these issues for us. So do listen and learn and think of great questions, and then please do direct them to our Office of General Counsel for any specific advice that you're looking for. And now, without further ado, let me introduce Greer Donley, who is a John E. Murray Faculty Scholar and Associate Professor of Law at the University of Pittsburgh Law School. She's a national expert on abortion and the law and has published widely and been quoted extensively in the media, especially on topics related to medication abortion, interjurisdictional abortion conflicts, and the impact of abortion bans on other aspects of reproductive health care, particularly pregnancy loss. Professor Donley's co-authored paper, The New Abortion Battleground, has been downloaded over 16,000 times, covered widely in the media, and cited by the Supreme Court's dissent in Dobbs v. Jackson Women's Health Organization, which is a huge honor for law faculty. She and her co-authors, David Cohen and Rachel Reboucher, regularly work with legislators, advocates, government officials, and abortion providers to identify post-Roe legal strategies and address the interjurisdictional abortion crisis highlighted in their article. They helped design, draft, and advocate for the first abortion shield law in Connecticut, which has now been replicated in many states and cities, often with their help. And perhaps most importantly, Greer graduated magna cum laude and Order of the Coif from the University of Michigan Law School and served as the editor-in-chief of the Michigan Journal of Gender in the Law. So we are so excited to welcome her back. Professor Donley, the floor is yours.
Hi, everyone. Thank you so much for having me here today. So as Kate mentioned, I am an alum of the University of Michigan Law School and feel just truly so grateful that I have so many friends and colleagues, mentors, and classmates that are at the University of Michigan. And so I was very much looking forward to actually coming in person to seeing so many people, but I am ironically in the middle of my own high-risk pregnancy right now. And, as a result, coming to terms with my own limitations. So thank you so much to the organizers for being willing to move this online for me. I'm really happy to be here, even if it's not in person. So today I'm going to be talking about the coming interjurisdictional abortion wars, and essentially an argument made by my co-authors and I, David Cohen and Rachel Reboucher, that Dobbs unleashed a world of legal chaos that is going to result in interjurisdictional abortion battles that will last years to come. Next slide. Great. So before I get started, I did want to congratulate everybody here on a tremendous victory in the last election, right? So here's, some of the news. Someone from the University of Michigan emailed me and joked, "I can't believe you aren't giving us more time to celebrate the in-state victories before we start worrying about what's going to happen outside of our borders." So I do want to apologize for that, but I also want to just congratulate everyone who worked on Prop 3 and voted on Prop 3 and led to this very important change in Michigan related to reproductive health and rights moving forward. Next slide. So our paper, this is a fully co-authored paper. So I want to just be really clear from the outset that David Cohen and Rachel Reboucher, my co-authors, everything that I'm talking about today is something that we collaborated equally on in this paper, The New Abortion Battleground, which is forthcoming in Columbia Law Review. So when we started working on this paper, which we started writing last year, we put it online in February. We essentially, a bunch of people argued that we were being pretty hyperbolic, right? That the chaos that we were predicting, where states were going to fight each other and fight the federal government, was not realistic. And this is in part because of a narrative that was crafted by the anti-abortion movement and has been kind of, operating under the radar for a while, that Roe and Casey and the doctrines that they created were unworkable. And the reason why this kind of argument came about is because, of course, in Dobbs had to confront the reality that it was overturning a nearly 50-year-old precedent that many people arguably relied upon. And to do that, one of the exceptions or one of the reasons to veer from precedent is when that precedent is unworkable. So for decades, the anti-abortion movement has been crafting an argument that Roe and Casey themselves created an unworkable doctrine because, things like the undue burden standard and viability were open to interpretation and had created a few circuit splits in the courts. And as a result, they said that this was a justification for overturning Roe. At the fundamental level, our paper is arguing that the Dobbs framework, right, where each state decides what its abortion policy is going to be, sometimes at the expense of other states and the federal government, is going to be exponentially messier. And so to explain this mess, you really have to understand that twin forces are operating in concert to create this chaos. Next slide. So let's start with the obvious one, right? Dobbs radically changed the law. Roe and Casey created a baseline where every state had to, or at least could not, prohibit abortion before viability, ensuring that there was at least some abortion access in every state, although people will be quick to note that the access was very disparate across states, right? Many states, even in the Roe and Casey era, had only one abortion provider left, and many people lacked, functional access to abortion. But still, compared to what we are seeing today, the access landscape has changed just enormously, right? So this is kind of from the Washington Post, which has been tracking this. I'll note for all of you here, the Michigan hand was orange before the elections, and now you are purple. And so what we see here is that since the Dobbs decision has come down, already 21 states have tried to completely ban abortion, and the courts have enjoined 6 of those, or 7 of those now, I think. And so there's only active bans in a group of those states, around 15. But this is a huge shift in abortion access, right? Even if some of these states only had one abortion provider left, you now have a whole region in the South without any abortion providers on the ground, forcing people to travel hundreds of miles, to take flights instead of car trips, to wait in lines at clinics in blue states that are often weeks and weeks long, just to access what many people view to be a fundamental right to healthcare. It also is increasing the costs, right? So the New York Times did a great piece on how many people are spending upwards of $1,000 or $2,000+ at this point to be able to access legal abortion in another state. Next slide. But the second force is the one that was a little bit unappreciated, we think, until very recently, which is that there has been a huge change in abortion access over the last arguably 2 decades, but really the pandemic radically changed things. So unlike the pre-Roe era, where abortion was really tied to providers, and therefore to space, right? Physical localities, physical space where people had to actually go to providers and get care with the procedure. In 2000, the FDA approved the first medication abortion regimen. For those of you who don't know, medication abortion is a way to terminate a pregnancy without any procedure at all, just by taking medication. It's a 2-drug regimen. The first drug in the regimen is mifepristone, usually followed 24 to 48 hours after with the second drug in the regimen, misoprostol. And so this is a very effective way at ending an early pregnancy. The FDA has only approved medication abortion through 10 weeks, although advocates are quick to note that the WHO permits it or thinks or has said that it is effective and safe through 12 weeks. And some providers in the US have started prescribing it off-label through 12 weeks. So for the first time in 2020, which is the latest data we have available, the majority of abortions in this country were completed using medication. We expect that that number is actually probably much higher now. And the reason why is that during the pandemic, right, the pandemic really revolutionized a lot of different healthcare sectors because of telehealth and the need for telehealth. Right. So if you guys can remember and go back to the early days of the pandemic, you'll recall that there were states trying to, essentially say that abortion wasn't an essential procedure, and people were losing access to abortion in the short term. One response to this was, well, we actually don't need people to come in person anywhere. We can ship them pills. We can meet over telehealth and ship them pills. The problem was that the FDA at the time had or still has what's known as a REMS, which is a protocol that actually limits distribution of drugs that the FDA has characterized as more dangerous than most, to require people to come in person, right? So there was this disconnect between what practice could offer, but also what the law required. So during the pandemic, you saw ACOG and other organizations challenge this law, saying there's, the justification for this, which advocates had for many years been arguing there should be no REMS at all. But especially in the context of a pandemic, there's no justification for why we should force people to travel in person and expose themselves to health risk to access this medication. And a court, the District of Maryland, actually for a period of time agreed, right? They enjoined the in-person dispensing element of the REMS. And when that happened, you saw researchers and advocates join forces to start researching what was happening, right? Because to get the FDA to remove the in-person dispensing requirement for good, researchers needed to show that it was safe. And so they really worked together to try to study this new practice, which was essentially what people called no-touch abortions, right? For the first time ever, really in the pandemic, and around 2020, we started seeing people being able to just access abortion purely by telehealth and with pills in the mail. Now, the research showed that this was safe and effective. And as a result, when the Biden administration came in, the FDA in December of last year announced its plans to remove the in-person dispensing requirement for good. So again, this is just ushering in an entire new way for people to access abortion. And in states that permit abortion, so after Dobbs, right, roughly half the country or more is permitting abortion. And in those states, you have virtual abortion clinics that are really innovating in this space by reducing costs, right? The average abortion is dropping by hundreds of dollars, which is a very important price point for many people, and increasing convenience, right? The average abortion patient is low income. They're already a parent. So doing things like ensuring that they don't have to find childcare, reducing the cost by a few $100s can really improve abortion access. So why does this matter at all for states that ban abortion, right? If you ban abortion, you're banning medication abortion. Well, it matters because pills are portable, right? They are changing the nature of how care is accessed, even in states that ban it. Why? Well, because there's organizations like Plan C and Aid Access and others where people are accessing this medication outside of the traditional healthcare system, outside of kind of traditional legal means through international providers. So Aid Access is the most well-known of these organizations. Aid Access essentially connects people in, let's say, Texas with providers who are in Europe. They will meet with the patient in Texas, talk to them, see if they're a candidate for medication abortion. If they are, the provider who is in Europe will call the prescription into a pharmacy in India, which will ship the pills directly to the person in Texas. So, let's not pretend that the anti-abortion movement doesn't view this to be, in contravention of their laws. But any attempts to really go after Aid Access so far have not been effective because the people, the providers that are at issue in this scheme essentially are all outside of a state's jurisdiction, right? The doctors are in Europe, the pharmacy is in India. There's no one in Texas to go after except for, and we'll talk about this in a minute, the patient, right? So traditionally, abortion laws were completely and totally tethered to the provider, right? Anti-abortion legislators targeted abortion providers completely, and that is how they stopped abortion in their state. But what happens when you have abortion providers who are outside of a state's jurisdiction providing pills to the people within a state? I'll note that there was a really interesting article that you can see on here about more kind of informal mechanisms that people are accessing medication abortion, right? So it's, aid access is using doctors that are in Europe, but you also have organizations like Las Libres who are more informally using kind of groups to get pills to people in red states as well. So basically, all of this is to say that pills pose an existential threat to the anti-abortion movement. And this is one of the reasons we can expect some huge changes in how the anti-abortion movement is going to act in this new climate. So it's, especially worth noting that not only do we have practice changes happening in this new climate, but we also have a current Supreme Court who has shown itself to be quite willing to affirm novel and creative attempts to stop as many abortions as possible, right? If you look at SB 8, that's the famous Texas law that essentially stopped abortions after 6 weeks in Texas, 9 months before the Supreme Court overturned Roe and Casey. You saw a Supreme Court that refused to enjoin that law, right? Almost admitting that it's going to allow anti-abortion groups to, experiment potentially with novel ways to stop abortion. So all of this just creates context and backdrop to explain, why abortion bans are not going to cut it if you are a legislature who is really committed to ending abortion, right? Pills mean that abortions are continuing to occur actually within your state because they're coming in, they're infiltrating your state, and people are getting access that way. We also know that patients are traveling, right? We know that many patients are leaving the state borders to go seek legal sources of care in other states. And, to the extent that you're an anti-abortion legislator who has said very clearly and from the beginning that your goal is to end all abortions, right? It might not be super comforting to you that people are finding new ways to access abortion. Your citizens are finding other ways to access abortion. So we know from data from SB 8 that if you look at what people did in that time frame, well, we saw a huge proportion travel and a huge proportion buy pills. And so, the numbers, the data is still being collected. We don't, from the post-Dobbs era, we don't have that, but, estimates range from something like only 10 to 20% of people are going to continue to carry pregnancies that they don't want to. And for the record, if you think that abortion is a human right, 10 to 20% is way too many. But if you think abortion is murder, you're really concerned about the 80% that are finding a way to end abortion in other ways. Next slide. So all of this is going to lead to new frontiers for anti-abortion states. I'm going to focus on this first one in this presentation, but I do want to mention a few others. The first is extraterritorial application of state laws. I think my co-authors and I think that we're going to start to see states trying to use every mechanism they have to end as many abortions as possible, right? You have an anti-abortion movement that has been very clear that their goal is to end abortion nationwide, right? If they had the votes, they would pass a federal abortion ban. In the meantime, you have in Dobbs folks who, as amici, wrote briefs saying that they are going to eventually try to have fetuses declared as persons under the Constitution, hoping to end abortion nationwide through the courts, right? So you know that that's the ultimate goal of the anti-abortion movement. And in the meantime, you can imagine state legislators and state prosecutors trying to use any lever they can, again, to try to chill and stop as many abortions as possible. And so we'll spend a lot of time talking about that today. But I also want to say, we have an emboldening of these states, and we have already seen their removal of many exceptions that, I don't know, 6 months ago, 8 months ago, people would have thought were just, accepted that they would be there. Already, we have many state bans that have removed rape, incest, and health exceptions, right? So far, life exceptions remain, but it's been shocking to many people to see some states debate that. And so, when you read news story after news story about how abortion bans are harming pregnancy care, pregnancy loss care, right? Things that you might not even think about as being related to abortion ban, people struggling to get access to treatments for lupus and arthritis and miscarriage management. It's because, in part, because of these health exceptions, especially in the context of pregnancy loss. And I'm happy to answer more questions about that in the Q&A. We're also likely to see states experiment or consider experimenting with criminalizing pregnant people and helpers. So, historically, criminalizing the pregnant person who had an abortion was considered, beyond the pale. It was unpalatable. But what happens in the context of self-managed abortion, where people are buying medication and abortion online, and the only person a state can go after, the only person in their borders, is the patient. So, we might start to see that. We're definitely going to see states going after helpers. We're going to talk a little bit in a second about the National Right to Life's model legislation, but one of the provisions of the model legislation was a recommendation that every state pass a law that specifically targets those who aid and abet abortion. So this would certainly help anti-abortion prosecutors go after, for instance, the mom who buys medication abortion online for her teen daughter. That's a case that happened in Pennsylvania, by the way, and the mom served 18 years in prison. So we're going to see more and more cases like that, where the friend, the mom, the boyfriend is targeted. And certainly, even states that, even though many states do not have statutes that actually allow them to go after the pregnant person, we know that even in the pre-Dobbs era, there were prosecutions of pregnant people for abortion-related crimes. And how that happened was usually through other types of laws, feticide laws, child abuse laws. Typically, this was people who tried to self-manage an abortion later in pregnancy, where if you take these pills, later after the first trimester, they often induce labor. And so, we see states that might choose to continue to use that. And then obviously we already have a few states that have passed laws creating personhood for the fetus. And that opens up really a number of different avenues for aggressive prosecutors to go after the pregnant person for abortion. Next slide. Okay, so we are going to really spend most of the time talking about this extraterritoriality part. So there's a few different flavors of how states might try to target or try to apply their laws outside of their borders. So the one that got a lot of press in the spring last year was out of Missouri. Those of you who know anything about abortion law in Missouri know that it's actually really unsurprising that Missouri is the place that's been thinking about this the most. They introduced a law in 2020 and then again in 2021, and that's because Missouri has actually regulated abortion so strictly that only a few hundred people were, even pre-Dobbs, able to get abortions in Missouri. The vast majority of Missouri citizens were getting their abortions in Illinois and Kansas, even before the Supreme Court overruled Roe. So Missouri, in other words, was already in somewhat of a post-Roe world before Dobbs. And so as a result, you had Republican legislators in Missouri that were visiting, Planned Parenthood built a very large abortion clinic right at the border of Illinois and Missouri. And so already for years you had folks Republican legislators in Missouri that were going and traveling to that abortion clinic, praying at that abortion clinic. So it was very obvious to them and on their minds that travel was really stopping their laws from having the impact they wanted it to. So Missouri last year, a legislator there introduced, it was not passed, but introduced a law that would create an SB8 style civil mechanism that would allow someone to sue anyone in Missouri who helps someone leave the state to get an abortion. This is, particularly scary for many people because, right, the SB8 style civil law, it creates kind of a buffer of judicial review. It's one of the reasons that because it's not enforced by the state, but instead by average citizens through the civil law, it made it so that the Supreme Court, remember, refused to overturn the original SB8 law or enjoin the original SB8 law while litigation was pending, even though it was clearly unconstitutional for a long time. So, we see many states that the Washington Post did a story about all the states that were considering passing this law in the future. So this is one way that states might go after trying to stop their citizens from leaving to get an abortion. It's worth noting too that this, anyone who's been thinking about and reading about the SB8 style law, that it really creates pretty scary incentives for people, right? Because it makes, if this law were to actually pass, it would make people really nervous about telling anybody, right, what they were considering doing, and really, creates a world in which the person who's getting an abortion has a reason to fear any person that could possibly turn on them and sue them, right? So the other thread, which is the threat of this is already impacting practice on the ground, is that states might target out-of-state providers. So again, we're going back, this section 6 here, this is copied from the National Right to Life's model legislation. For those of you who don't know, the National Right to Life often creates model legislation, and that legislation is often just passed in many states in the next legislative cycle. So that's why people do pay attention to it. So here you have section 6, which says, the important words at the beginning: regardless of where an illegal abortion occurs, a person who knowingly or intentionally recruits, harbors, or transports a pregnant minor who is a resident of this state, let's assume Missouri, with the intent to deprive the pregnant minor's parent of knowledge of and to procure an illegal abortion or to obtain an abortifacient, commits promotion of illegal abortion, trafficking of a minor, right? So this would essentially allow states to go after any abortion provider if it were passed, right? Again, this is model legislation. No state has passed this law. But if it were passed, this would allow states to go after any abortion provider who provides care for a minor out of state. Right. And so, again, when you really pay attention to the news stories that are written where the anti-abortion folks are commenting on the record, this is certainly one area that they have expressed a lot of enthusiasm for. I think the idea here is to, really test the waters of extraterritoriality by focusing on minors, where they think they might be on more solid ground, and they might be less likely to alienate voters. But this is not the only way that states could target out-of-state providers. One way that has come up a lot in our conversations with advocates and providers on the ground is just how medication abortion operates and works, creates really novel legal arguments. So before medication abortion, it was really clear where an abortion occurred, right? It occurred where the person got the procedure. But when you have medication abortion, we have no way to know how courts are going to define where an abortion occurred. Does it occur where the provider is? Does it occur where the patient is, if that person is in a different state? Does it occur where the patient picks up the medication abortion regimen, right? If a patient travels from Texas to New York and they pick up the medication, they meet with the provider there and pick up the medication abortion regimen there, does it occur there? What happens if the patient travels back and takes the second medication in the regimen, which is supposed to be taken 24 to 48 hours later in Texas? Right. In general, the standard of care typically was when people were traveling to get medication abortion at a clinic, they would pick up the medication there and they would often go home and take the second part of that pill at home, right? Because the meso, the second part, starts contractions, right? You don't necessarily want to have a patient who is contracting and cramping and bleeding on a 12-hour drive home, right? So in particular, it was common for patients to take that pill home and complete the abortion in their comfortable place of residence at home. But because of that, it creates the opportunity for states to argue, as they have already gone on the record saying they will, that if any part of the medication is taken in their state, then the doctor knowingly provided an abortion in their state, right? So that is the concern. And already you have certain clinics that are refusing to provide medication abortion for out-of-state patients because of this risk. Many of you might know that NAF, the organization that provides the most abortion funds for patients, had a statement that it is currently reevaluating that it was going to not provide any abortion funds for out-of-state patients using medication abortion unless they said that they would stay in the abortion permissive state while they took the whole dose of the regimen. And so you see this impacting clinical care, and you see this creating a lot of anxiety among abortion providers who are, in places like Michigan, but in places, blue states, you see, people, these providers are seeing a huge influx of out-of-state patients, obviously. They want to help them, but it is very nerve-wracking to know that they could potentially become a target by just, staying completely in their borders, doing everything completely according to their state's laws, and still red states might try to find a way to go after them. Okay, next slide. So first I want to talk really briefly about whether or not this is constitutional, right? Many people, their initial reaction to this is, well, states might try to do that, but that's unconstitutional, right? Presumptively, we have a right to travel in this country and to take advantage of other states' laws. Many people, from going to Las Vegas to gamble, going to Colorado to smoke weed, the presumption is that you can, go to another state and take advantage of their laws, even when your state's laws are different. The problem is that this right to travel has not really been tested in this way in the courts. There's very little case law about it, right? You just don't see instances where Alabama is trying to prosecute someone for going to Colorado to smoke weed. And so we just have very few cases to really evaluate how strong or this right and to the extent that it exists. It's also worth noting that many of the doctrines upon which a right to travel would be based are themselves on shaky ground, right? Probably the best one is substantive due process. Well, Dobbs, Dobbs overruled Roe, which was one of the foundational cases of substantive due process. We have privileges and immunities clause, which has been applied very narrowly. The dormant commerce clause could potentially be used, but one of the threads of that clause about extraterritorial application has been under attack by conservative justices, most famously Justice Gorsuch. And so, again, you just have a lot of uncertainty. Scholars have been debating whether or not a state could ban their citizens from traveling to get an abortion for decades, reaching completely different conclusions about whether the Constitution would permit that. And then this all gets really a lot more complicated when you start throwing in states with personhood laws, right? Where you have a state like Georgia that says a fetus is a full person under our laws, where, ordinary criminal laws like conspiracy and murder could be theoretically applied to those, to cases of abortion, and the effects doctrine could come into play. So, my co-authors and my position has always been that this should be unconstitutional, but the legal question is not black and white. And with the current makeup of the Supreme Court, there's reason to be quite cautious, and there's reason why providers are afraid. So one of the things that we have been working with state legislatures to do is to pass what are now being called abortion shield laws. So we worked with legislators in Connecticut to draft the first one that was passed there, and has now been passed with others in other states as well. So Connecticut's law, for instance, has a clawback provision, which would allow folks to recover from any sort of a civil damage. So if there's, an abortion provider who is sued under an SB8 style law and is now facing a default judgment in another jurisdiction, then they will now be able to sue in their own jurisdiction to recover those damages. Probably the part that's gotten the most press is the fact that shield laws prohibit extradition of providers charged by out-of-state prosecutors. So the Constitution does require states to extradite fleeing criminals, people who are accused of fleeing a crime, but it says nothing about whether or not a state has to extradite someone who never fled, right? And so this is pretty clear that states have the authority to not extradite when there's no evidence that the person is fleeing the state. And so this would simply go back, force states to go back down to the constitutional floor, saying that they're not going to extradite their abortion providers or any citizens who are charged by out-of-state prosecutors for abortion-related crimes. It would also stop courts and government officials from complying with any sort of out-of-state investigation into a provider or a helper or patient for an abortion-related crime. And then it would protect the medical records from being discoverable for those same things. We then have, that was basically what Connecticut did. Connecticut, we were unable to get a few other things passed, but then in New York decided to copy Connecticut and add some additional provisions where they also protected physician licenses and their malpractice insurance, which is, a really important part that folks often ignore for abortion providers who, very much care probably more about their licenses than anything else, because that's, obviously how they make their income. It also protects the identity of abortion providers. So, I'll just say at the outset here that these shield laws, as originally drafted and intended, would not protect providers who are sending pills into red states for patients who never left the red state. But it would protect doctors and helpers who are in the blue state treating patients that are coming to them from out of state, even if a red state views that as illegal, right? So if the National Right to Life's model legislation passes with regard to minors, and in Connecticut or in Missouri tries to go after a Connecticut provider for providing an abortion on a minor from Missouri, right? The shield law should come into effect so long as the patient actually traveled to Connecticut. Massachusetts decided to be the most, to go even further in a way that has created a lot of controversy, even in the abortion rights movement, even amongst people on the same team. In Massachusetts, they decided to also shield providers who are shipping pills into red states for people who never leave. As far as we know, Massachusetts is a new law. We don't, so far, we do not know of providers who are actually doing this, but there's a ton of advocacy working in other states like New York where they have very progressive doctors interested in doing this, where they are hoping that New York will extend their shield law to allow this next year. Thanks to, the historic election you just had in Michigan, Michigan could be one of the states that passes a law like this to really protect its providers in this new era. Next slide. So I'll just mention that it's not just interstate conflicts that are going to come up. You also have the federal government that is already trying to do what it can, right? It can only do a limited number of things without a legislature that's able to pass a abortion protecting law. But with a progressive presidential administration, the executive branch itself does have some ability to make a difference at the margins when it comes to abortion access. And you see the Biden administration right now trying to play a role here and using its limited power to try to make a difference. So one of the ways that I expect we're going to see come up a lot in the courts, but it hasn't quite yet, is preemption using FDA law. So, just a really basic rundown of preemption is that, the supremacy clause of the Constitution says that when federal and state laws conflict, the federal law will trump. Well, there are a lot of federal laws that arguably could be used to preempt certain state laws. The biggest one, right? The one that would actually make a huge difference in abortion access across the country, if it were to be accepted by the courts, is the idea that states cannot ban an FDA-approved drug because federal regulation of that drug trumps any sort of a state regulation. There is a case out of Massachusetts where Massachusetts tried to ban a controversial opioid in the middle of the opioid epidemic. And you saw a court say, no, you can't actually do that, Massachusetts. You can't ban this FDA-approved drug. And so, this is actually a very complicated argument. There are a lot of reasons to think that it's not going to be successful, but it's novel, it's exciting. If it were to be accepted by a court, you would see a huge medication abortion size exception in every state's abortion law, right? Where you would imagine that states had to permit the sale and distribution and use of medication abortion through the FDA-approved label. So that would essentially allow abortion by medication through 10 weeks of pregnancy in every state. The vast majority of abortions occur in the first trimester. So this would actually be a huge deal if it were to be accepted. The other ones here are much smaller, much more marginal impacts, but you see them already kind of taking hold in the courts. So EMTALA is a federal law that says that any hospital that accepts federal funding and has an emergency room has to provide stabilizing treatment for folks who are experiencing medical emergencies. And it turns out, right, that this is a much broader definition than many state laws, which lack any sort of a health exception, right? So theoretically, EMTALA would trump those state laws and say, no, you have to provide medically necessary abortions, even if your state doesn't have a health exception, consistent with EMTALA. And so we've seen the Biden administration really take to this argument. We had the Biden administration issue guidance on this. Texas challenged that guidance and won in Texas. The Biden administration sued Idaho, saying that EMTALA trumps Idaho law, and won there. So, we could theoretically imagine that this creating an eventual circuit split between the 9th and 5th circuits that the Supreme Court might have to resolve. There's also HIPAA. HIPAA is a federal health privacy law that basically says people who are covered under the statute can't share protected health information. And so the Biden administration issued a guidance document saying that, even in the context of potential criminal activity, that's going to apply unless a HIPAA exception is met. The most relevant one being whether there was a warrant for that information, in which case the hospital, the provider can give the information to the police. But theoretically, HIPAA would prohibit someone, a healthcare worker in Texas, who suspects someone who comes into the emergency room bleeding, that they might have self-managed an abortion. HIPAA would potentially stop that person from reporting that person to the police, assuming the police have not come to them first for requesting information. And then the Biden administration also is using the Veterans Administration, right? The VA just promulgated a rule, an interim rule that would say, even in states that ban abortion, you have to provide abortions for veterans who are needing one due to rape, incest, or health reasons, preempting, again, state laws on that conflict. So, the hard part, the part that the courts are going to be dealing with is trying to assess if there is a conflict and in what context. And so, the kind of, I'll just conclude with saying we don't actually know how any of this is going to be resolved. We're going to have to wait and see how it's all resolved by the courts. But we do know that the fights here could be endless, and that the idea of that overturning Roe will get courts out of the quote abortion umpiring business is completely false. In fact, we're going to see a lot more need for court intervention in the future. So I'll stop there and be happy to answer any questions.
Thank you so much, Professor Donley. Sorry, I'm here, trying to find a paper bag to breathe into, but we're going to be okay. That was really helpful information and so clearly presented for our really diverse audience, and I really appreciate that. We're getting a lot of good questions. I'm going to start off with some trying to channel my OB-GYN colleagues. So we don't have a shield law, as you mentioned, in Michigan, but in July, our governor did pass an executive order, like a non-extradition executive order, saying we wouldn't extradite patients or providers who are accessing reproductive health care, which is actually pretty broad. So I guess my question for you is, Michigan providers have been acting as sort of like a surge state right now and for the foreseeable future of all of those ban states coming up. So if as an example, a patient from Texas comes to Michigan, procures an abortion and then returns, and the state of Texas wants to prosecute one of our providers, two questions. One, does that mean that our providers can no longer, these are very practical, but can no longer go to conferences in that state because there'll be a warrant or a civil warrant out for them? And or if Governor Whitmer says we won't extradite people, can you explain to us whether and if the state of Michigan can prohibit police officers from Texas to come and physically take people out of the state? Can you give more clarity on what that impact might actually mean for our providers?
Yeah, so great question. So I think there's 10 executive orders. So there's more executive orders than there are shield laws. In general, the executive orders are less protective than the shield law because the governor by executive order cannot do all the things that the shield law does. But one of the areas that I think is probably the most protective is related to extradition. And so I do think that the fact that you have that executive order from your governor at least with regard to extradition, I think your providers should feel fairly confident that they will not be extradited. I think I can't say I know the answer to the practical question of what happens when can Texas send folks into a bounty hunter into Michigan. We have been operating under the assumption in our conversation with abortion providers that travel is going to be to red states is going to be a complicated risk assessment that they have to do on their own in this new world. So especially for the abortion providers who are pushing for states to extend their shield laws so that they can send pills into Texas. Those people in particular, we assume if they choose to do that, would be the highest risk, right? They would be the target number one of prosecutors in Texas. And for those people in particular, we have been very clear that if they choose to do this, which is still risky, even with a shield law, that they would need to be very careful about travel. What happens if they, are a New York provider who's flying to California and their flight is, there's weather and their flight is put down in Missouri, right? I mean, all of a sudden there's things like that, that are, really kind of the type of questions that no one thought they would be asking a year ago, that seemed totally crazy, that all of a sudden people are evaluating as if they're genuine concerns. And so for those folks, we are being very clear that you need that people who are willing to do that need to be very careful about travel. For the provider who is providing abortions completely in Michigan, right? It is not sending pills anywhere, especially those who are providing procedural abortions on out-of-state patients. I think their risk is much lower just in general. I think, especially when you're talking about procedural abortions where, you don't have the same kind of argument about where did the abortion occur. I think the risks are, the legal risks of any sort of out-of-state prosecution are pretty low. Doesn't mean it's impossible. Doesn't mean that you couldn't be the person that does the abortion on the minor who has the crazy parents from the crazy state who are going to do whatever they can. But in general, I think the risks are lower. I get more worried about the providers who are prescribing pills. And again, if you're in a state with a shield law prescribing pills, I think you're safer. But one of the things that we really try to do as a team when we do talk to providers is say, like, we're in a new land of risk evaluation, right? Risk management. No one can tell you anymore that everything is perfectly safe. All people can do with so much uncertainty and so many unknowns is try to counsel you on the types of risks that are out there, right? A lot of these risks so far are kind of theoretical, right? I mean, we heard a conversation from a reporter who was talking to us about our paper and then also talking to someone in the anti-abortion movement who said some version of like, Planned Parenthood is our biggest ally right now because all we have to do is make a threat and then they tell their providers not to do it. Right. And so like there is also concerns that we are being our own worst enemy here because there hasn't actually been any attempt at an extraterritorial prosecution. Right. So like all of these risks are theoretical right now. They exist on a spectrum to varying degrees. And unfortunately, abortion providers who are doing amazing work right now under horribly hard circumstances are forced to evaluate, what risks they're willing to take in this moment and not.
Okay. Sorry, I'm just like absorbing and also reading all these really good questions. Okay, so another one. So you talked to us a little bit about the mifepristone lawsuit in Texas and how it was dropped by Gen Biopro, right? So they decided not to pursue, the manufacturer decided not to pursue it. And you talked a little bit about that circuit split for EMTALA, but what do you think? What do you think so Gen Biopro has said, we're going to do something else. We're just not sure what it is yet. Like, what do you think they should be doing?
Great question. So just as background, for those of you who didn't read the paper, the lawsuit that we're talking about was originally in Mississippi. So it was actually a pre-Dobbs lawsuit that was started. And the argument was kind of based on this FDA preemption argument. The idea here was that Gen Biopro, which is the manufacturer of mifepristone, the generic mifepristone, sued Mississippi saying that your laws, which go way above and beyond the REMS, are preempted by the REMS, right? The REMS is the ceiling and you cannot legislate above it. Then Dobbs happened, right? And Mississippi passed an abortion ban. So what initially Gen Biopro did is it amended its complaint to say, hey, our case is only stronger now because now you're completely banning our product from sale in your borders. Then Mississippi replied, raising this very unique argument that you can expect to read about in the news eventually, called the Comstock laws. So the Comstock laws are pre-Roe laws that is federal statute still on the books because we never repealed it because Roe made it unconstitutional. That basically federally prohibits the use of mail to ship anything for abortion, right? Theoretically, if Comstock is still a good law, it could theoretically ban abortion nationwide because every abortion provider relies on interstate commerce to get, the speculums and the tubing and the medication, right? So the argument here is that you at least can't use preemption because federally, there's no actual federal protection for any of this medication abortion stuff. So what happened is Jen Priopro made the probably wise decision that if this was going to get litigated, it probably was not good to have it in that circuit and in that court, and they voluntarily withdrew their lawsuit. And so the question now is when and where they're going to try this argument again. And I think, my guess is we're still waiting for the FDA to kind of release its final decision on the REMS update based on removing the in-person dispensing requirement. And I think, I would suspect that there's enough uncertainty out there that they're going to pause and wait and see what happens with the federal government first. And, we'll have to kind of see what they choose to do in terms of jurisdiction shopping. As to EMTALA, I unfortunately haven't been following it super closely the past few weeks, but my guess is that we're going to see an appeal for those cases, the case out of Texas and the case out of Idaho, to the Fifth and to the Ninth Circuits, which historically are viewed as a conservative and a liberal circuit, and they're in slightly different procedural postures, but we're just going to have to wait to see what the courts do there.
Thank you. Okay, so we only have 4 more minutes, but we have a couple of good questions. So I'm going to put 2 together, and then you can just reply to what you want or what you think is the most important. So we've been talking a lot about interstate territoriality and extradition. What about international? Right. So that was one of the first examples you gave. Do you think a lot of this will move to the international stage? And how much should our providers be worried about entrapment? Like, can you actually be entrapped into violating these laws if somebody in the state of Texas, if it becomes illegal to send medication, can somebody in the state of Texas call and have a Michigan provider send them medication and be like, aha, I'm not even a real patient? How much of a concern should that be?
So first, hi, Nicholson, since I can see the international question. I do think, one thing that's really interesting about the international question is that the FDA under the Trump administration actually tried to go after aid access at the time, right? So already the anti-abortion movement knew aid access was shipping pills into red states, and they pressured the Trump administration to go after them. The FDA tried and was not able to stop it. So, I'm not an international law expert at all. So I would be really curious to have folks who are weigh in on kind of the levers that the United States under a potential future Trump administration could use to try to target aid access and international organizations. But so far they have not been super successful. And so I think we're going to start seeing a lot more of kind of the immediate attention and targeting is going to be on Plan C, is going to be on abortion funds. It's going to be on the folks in the United States that have a pretty national presence that are helping folks get out of red states and into blue states. And then as for entrapment, I do think it's something that's something abortion providers have been worried about and have to worry about, and only more so now. Already you probably, for those who have been in the movement, know that anti-abortion people have, for a long time pretended that they're going to be abortion patients for the sake of video recording and taping and trying to get abortion providers in trouble. So certainly, I think that is always worth being concerned about in this new environment as well. And unfortunately, I think one other concern we are now going to have is that patients are entrapped, right? That when patients eventually go and try to Google how to buy abortion medication, anti-abortion groups are going to have fake clinics online that are completely designed to try to entrap them and to report them to prosecutors. And so, I think the entrapment's going to operate in different directions now.
Thank you so much. I'm sure we would be delighted to ask you questions for the next 5 hours. I'm not sure how you would feel about that, but I did just want to end by saying thank you so much again. Amy, do you mind linking to Professor Donley's article that she was talking about in the chat? I'm also happy to tweet it from CBSSM so you guys can read more about it. We are very lucky to have you come and share not only your academic expertise, but be an example on how academics can also be activists and actually get better law passed and help inform those. So thank you so much for coming. We really appreciate it.
Thanks for having me. It was great to be here.
Thanks, everyone.